this episode, we're going to be talking about experts within civil procedure. There's a lot to cover here, so just buckle down and enjoy the ride. So there are two main types of witnesses. The first witness is going to be a lay witness, and they focus on the fact. The second kind of witness is an expert witness. And so what's the main difference? Well, first, a lay witness has special knowledge about the case. An expert witness, they don't testify about specific facts, but they testify about their opinion. So lay are fact, expert are opinion-based, and their opinion is based on trying to interpret what the facts mean and what impact it may have on the case. So, what defines an expert? An expert is a person who has knowledge that is outside the range of a normal person. So, in other words, a person with specialized knowledge. A mechanic is an expert in mechanics. A rocket scientist is an expert in rocket scientry, whatever that is. I am not an expert in vocabulary. But there are several different categories of expert witnesses, and that is because experts are used in several different ways. First, there are testifying experts. Second, non-testifying experts. Third, consulted but not employed experts. Fourth, fact witness experts. We'll spend a lot of time there. And finally, independent experts. Let's just go ahead and talk about the definition and where they may be applicable. A testifying expert, as you might expect, is an expert who the attorney plans on utilizing at trial. These individuals are subject to discovery without a court order, and that's according to Rule 26b4a. And this includes any communications that are occurring between the attorney and the expert. This is not privileged information. A non-testifying expert is a person who the attorney consults and talks with, but they are only there to help prepare for a case, and they're not planning on using them at trial. These individuals are only subject to discovery if these circumstances are exceptional, and that's outlined in Rule 26b4d. So next, we have consulted but not employed experts. These are going to be experts who were interviewed to be experts, but the attorney decided not to use them at all or hire them at all. Often, these are going to be experts who disagree with the lawyer's position. Because they disagree with the lawyer's position, their names and addresses are not discoverable. At least that's what most jurisdictions say. There's a few that may differ on that. So now we have fact witness experts. This is an expert who also meet the requirements of a fact witness. That is, they have direct information related to the case as well as a heightened knowledge to provide an opinion for the case. So a good example here is going to be an emergency room physician. The physician worked directly with the injured individual and knows specifically what happened to that individual based off of that personal knowledge, but he's also an expert because he's a physician in the medical field. So finally, we have independent experts. Fact witness experts. Fact, not fat. They're treated as lay witnesses, which means that they are not able to invoke a work product privilege or expert privilege. They can be discoverable. Finally, independent experts are individuals who have relevant expert information, but they need to be reasonably compensated for that use. They're not used at trial or anything like that. It's you published an article, I want to use your article, and so now we need to pay you for your article, pretty much. So their information may only be subpoenaed if they are reasonably compensated, and that's according to Rule 45C 3B. So how do you discover a non-testifying witness? Because testifying witness is easily discoverable, but there's only certain circumstances where non-testifying witnesses can be discoverable. And that's really where things get a bit interesting. So we have here two cases, Thompson versus Haskell Company. And this is a case where a person was terminated from her position, and she ended up suing them. And she got a psychological evaluation related to that directly after her termination. But she sued several months after, I believe about 10 months after. And so the defendant in this case says, we want to hear what was going on in that psychological evaluation. One thing to note is, wouldn't this be psychotherapist-patient confidentiality? And although that's true mostly, this privilege is actually going to be waived. It's kind of a special exception because the client was suing for emotional damages. Well, if they're suing for emotional damages, you need to know what they were talking about with their therapist. So that's kind of waived, and now we're talking about this person is a non-testifying witness. They're normally protected. Are there any special circumstances that is going to merit discovery? So the plaintiff had obviously consulted with this psychotherapist and determined not to use this expert. What's this mean? It means that it's an expert who pretty much does not agree with the plaintiff. And so the defendant wants to actually get this information, and the plaintiff is trying to protect this psychotherapist, her report, from being discovered. So the court, in this case, determines to grant the request to discover the report. And a large part of this is because she suffered injuries at the time of the event and had the evaluation at the time of the event. And that's the really big kicker, because now we're 10 months later and her mental state has changed, because people's mental states change frequently with the passage of time. So her mental state is not the same as it was when she had that original information. And the defendant doesn't have the opportunity to conduct an additional evaluation because she's changed. And we need to know what happened then, because that's what she's suing about, is what happened then. And this is now. And so there's no other way to obtain this information except to go through this psychological evaluation that had occurred then. So the request to protect the information is denied, and the defendant would be disadvantaged if it was granted. And it's because, sorry, I don't really get my last note there, so I'm going to go ahead and skip over that. So that's related to that. Our second case related to expert testimony is, I can't pronounce it. We're just going to say the banana reefer case. It was a case where there was a whole bunch of damage caused to crates of bananas just because of equipment that was on the machine, and so the company is suing the reefer, saying, hey, you damaged this, and we want to collect on those damages. And what happened here is that an expert witness went onto the boat and they found something new. And so the defendant here is trying to say, hey, we want to, this person is a fact witness because they discovered something new that was related to the facts of the case. And a fact witness is typically not protected, even though they're not a testifying witness. Now, the issue here, though, is that the person went onto the boat at the same time that the claim was being made. Sounds like the rain's finally come. So here, the court determined that this person was a non-testifying expert, and so his material is not discoverable. and it is only discoverable if there are exceptional circumstances, and those exceptional circumstances are lacking here because the reefer also had experts on the boat who could have found what this expert found. They were not disadvantaged by any means, and ultimately it's a way of avoiding the free rider problem once again. So that's how expert testimony is protected, the different kinds of experts, fact experts, as well as non-testifying and testifying, and what kind of material is protected from discovery based off of their status as an expert. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro, and you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.